Pratham, I can't see anybody.
You are not there. There, between the off, you can see you because you are not.
Well, how are you?
Yeah. Hanji, sir, how are you?
Very well.
ये घर का ऑफिस है?
जी.
Very good. Nice. Like it. और सर क्या हो रहा है?
बढ़िया.
तो आपका आप तो कोर्ट में गए थे आज?
हाँ जी, हाँ जी.
Yes, I saw in the court today.
On the court.
I saw you in the court today. In your court today.
You see, the son was there. I said his name on the. He did not switch on.
See, I never knew that he was having a matter, so I just went to his room. Then I heard you talking.
He did not switch on the video, the camera.
Huh?
I couldn't see him. He did not switch on the camera.
Normally, that's what they normally don't do it. Why? Because the person who's doing the talking, then only they are there. So the others don't want to switch on their cameras.
Hello, sir.
Hi, how are you?
He's the one who's helping me. I would not have been able to get through this thing here. We are not that technical savvy,
That is true.
That is right. Where is the big boss? हम दोनों ही हैं मेरे ख्याल तेरे I can't see anybody else here.
Where are the moderators? I can see Mr. Kamal Chaudhary's name being flagged, but
I can't see him anywhere because the other one said that there was no electricity in his office, so he was just rushing to another office.
technical fault.
Yeah. Hello. We can't see you on the chat, on the web. Hello. Because hello. No, we can't see you. Have you muted it or what? You have to put on the camera, switch on the camera.
Switch on the camera.
Switch on the camera. There are two things, which is one is the mute button, the second is the camera button. When these there are no, I can't. I can see you.
Yes, it's come now.
Now we can see you. Yes. Now we can see you. And yes. Is Nikhil? Okay. I think Justice Andlaw has also come.
Looks like it.
Hi.
Hello, sir. How are you?
Good. What's happening? Nice color, Jane.
Thank you.
He's looking bright. As always.
Hello, Mr. Chaudhary. Mr. Kamal Chaudhary, how are you?
Mic is off. Yes.
Sir, good evening. How are you, sir?
I think
Am I audible now?
Yeah, very much.
Oh, great, sir. I'll just check up where is Nikhil. Just a minute, sir. Yes, yeah. Care password 67. Nikhil, second में से login करो. Please join. Second में login करो. I know. I know.
Nikhil was saying,
Is there any password, sir? No, there is no password. You only have to enter your name as a participant there. First thing. And submit. Join event. Start your event. You're not the host. I'm the host. You're a panelist. Okay. Down. Hello. Click on join event here. Nikhil, after submission, please join event.
I think he was having some issues with the electricity there in his office.
From today, all of us are back on rails.
Sorry, I couldn't follow you just a second.
I'm saying from today, all of us are back on rail.
That's right.
I have finally managed a job today.
हाँ जी कर दिया. Okay. He's there. Nikhil.
Hello.
Nikhil, can we start?
Yeah. Am I there?
Yes, you're there.
This meeting is being
Yes, we can hear
recorded.
you.
Good evening, everyone. I welcome you all and I hope everyone is safe and doing well in these difficult times. As we all know, every possible place in Delhi is now open, but I urge to my friends, my seniors, my colleagues to restrain themselves at home and not to go until unless it's really important. And if they are going, to take all precautions necessary to fight this COVID. Coming back to the topic, today's topic is law of testamentary succession in India. Few housekeeping rules before I introduce our panel. During this session, question can be put in the chat box at your screen and we will look to accommodate as many questions as possible. The lockdown has proved to be a blessing in disguise, as much as it has given us an opportunity of hearing the best legal minds and having benefit of their immense knowledge and experience. The panel with us today needs no introduction, but I would be remiss if I do not say a few words of introduction of our distinguished panelists. Our first panelist is Justice Rajiv Sai and Law. Justice and Law, as an advocate, had a vast and distinguished practice, specifically on the civil side, and since his elevation on the bench, has authored several landmark judgments virtually on every aspect of civil law. We could not have asked a better speaker to address us on the topic before us. Thank you, Justice and Law. Our second and equally distinguished panelist is Honorable Justice Jayannath, who before his elevation to the bench has been standing counsel for various PSUs and had a varied areas of practice in across several jurisdictions, be it service, labor, arbitration, or civil law. After his elevation, Justice Nath has authored various landmark judgments. Thank you, Justice Nath, for being here with us and to share your knowledge and experience on the topic before us today. Before I continue, one thing, being a young lawyer of the bar, I must say, both our honorable judges have a lot of popularity among the youngsters. Coming on to our third panelist, Mr. Sandeep Agarwal, Senior Advocate, Delhi High Court. Mr. Agarwal is a practicing lawyer for more than 3 decades on the civil side and is a very prominent lawyer. I welcome you, sir. We also have with us Mr. Kaval Chaudhary, Advocate, Delhi High Court, as a co-moderator. Mr. Chaudhary has a wide experience of more than 25 years and has conducted several testamentary trials. Without further delay, I would request Mr. Chaudhary to continue from here. Mr. Chaudhary, sir. Mr. Kamal Chaudhary. I think there is some network issue.
I think he is to unmute himself,
Mr. Kaval, sir, please unmute.
Am I audible now?
Yes, sir.
Yes.
Thanks, Nikhil. Thanks so much for all your support. Very good evening to my Lord Justice Anlo, my Lord Justice Jayannath, Senior Advocate Mr. Sandeep Agarwal, and all the attendees to this webinar. A warm welcome to you all. Thank you so much for your lordships for sparing your valuable time today in joining this webinar, especially after taking up the matters for the entire day today. Today's subject, law of testamentary succession in India, is a law dealing with succession resulting from a legally executed testament which confers right of inheritance. So therefore, if you have a valid will, you are said to the state, meaning thereby that you have spent out its intentions completely and legally in your last will or say testament. Though the subject is quite vast, however, in these hours' time, we would confine our discussion primarily on the construction of will, jurisdiction, remedy available amongst the probate or suit, nature of evidence required, and the circumstances under which the probate may be declined. In view of this, may I ask my Lord Justice Andlaw as to what all is to be kept in mind while actually making a will. My Lord Justice Andlaw.
Hi, good evening, everyone. Am I audible, Mr. Chaudhary?
Yes, sir, you are audible. Audible, sir.
Yes, sir, you are audible.
Yeah, in fact, this subject which you people have chosen is a very, that way, a unique subject, considering other subjects on various webinars have been held in the last 2 months. And I would say it's a niche subject, but which nevertheless falls in the very core of the civil law litigation. Now, as far as what has to be kept, because see, ordinarily, any person desirous of making a will would approach an advocate, because lay persons do not know how to go about making a will. Though, let me warn you, one advocate from my batch, Subodh Verma, he had joined litigation with me in the district court. He was my batchmate in the law college, and he was he was not enjoying litigation. And then he wrote this, I still remember, about 70 pages book, How to Make Your Own Will. And it was a roaring success. It sold on all the Wheeler bookstores in the railway stations. And I think within a span of about 6 months or so, he made a lot of money. That was the first book of its kind which had come out. And see, he identified the niche audience for it. He identified the niche distributor for it. Because that kind of a book, if you go to a bookstore in a mood to buy fiction, you would ordinarily not buy. But when you have about 4 or 5 hours or an overnight to spend on a train, you would pick up this book from the Wheeler books store on the railway platforms. So after that, there have been a lot of books on the subject, and but still a large number of people approach the professionals for drafting a will. Now, having said that, let me also clarify that a large number of such persons ordinarily would not come to litigators like you and me for drafting a will, because making a will is somehow assumed to be coupled with or tied up with registration. So they would visit a registrar's office, and the advocates practicing there or the deed writers practicing there, they would approach them. Even for that matter, even the typists who are sitting there and who over the years have become experienced in also making wills. These kind of people, I would say, majority of the people would approach them. But yes, people who have considerable estate or people who are anticipating a dispute amongst their heirs, they would approach a litigator like you and me for making the will. So it becomes very important to know that what all one has to be careful about while making a will. And I'm addressing this not to Mr. Kamal Chaudhary, Mr. Nikhil Mehta, I don't know too well. I don't know how much experience, but Mr. Chaudhary, I know he has plenty of experience, so maybe what I say may not be of relevance to him. But if I was to list out, I would list out firstly what I have been saying repeatedly in law colleges as well as at various platforms where I get an occasion to speak as a judge. It's very important for making a will also to listen first. That to understand the requirement of the client. So first comes listening, because only when you know what he desires can you implement his wish on paper. The second thing is the advisory role of an advocate, because very often as a lawyer and as a judge, we come across wills which, rather than simplifying succession, complicate it further. Now, the whole purpose of making a will is to minimize the possibilities of a dispute and to ensure that the succession is without any hitch and without any trouble. Whosoever the testator desires should get the property, gets it without any trouble. So, but it is often found that a will, instead of serving that purpose, does a great disservice to that. Then the third thing I would highlight is that without again knowing the background of the person who has approached you, you cannot just go about drafting a will. It's not a, see, he doesn't approach. I am sure today there must be software programs available where you can feed make my will. They'll say feed your name, feed your children's name, whom do you want to leave to, and a will come out. And if they are not already there, I'm sure they'll be there within a very short time. So the person is not approaching a machine to make a will, he is approaching another human being. So satisfy those requirements of a human being, you have to pick up the things which the machine would not pick up and which you as a human being can appreciate and translate it into paper. So you have to find the person's emotions, understand what language he is familiar with, what is, whether he is in employment, whether he is in a business person, what is the language he is used to, how he has been signing in day-to-day things, who are the various people. So all these aspects you have to take care of while drafting his will, so that there can be no challenges, because the first thing to keep in mind while making a will is to ensure that it's a 100% document, and the challenge, even if, and to proceed on the premise that yes, a challenge will be made to it. Now, having done that exercise, the next step comes. A lot of people feel that they have to make a very flowery document or a very impressive document, which anybody who reads will say, oh wow, who made this will? But that serves the opposite purpose. So the language of the will has to be very simple, ideally short sentences, and leaving no ambiguity whatsoever about it. Now, the one other thing which I feel a lot of us forget about, and I realized it after about 10 years in my professional life, and I'll just narrate that because according to me that incident is a fit case to understand what I am saying. Very few, see, the Indian Succession Act is a very neglected act. Very few of us are aware of the provisions of it. Even if we are aware of the provisions of it, only those provisions that all right, in which territory the probate is to be filed, what is a probate, what is a letters of administration with will annex, what is a succession certificate. But a large part of that act is concerned with the construction of wills. Now that very few of us are aware with. At least that's been my experience of 38 years at the bar, that hardly anybody knows those provisions. So it is those provisions, when ultimately you come down to brass tacks challenging the will, it is those provisions of construction, interpretation of the will which come in handy. And you find that what the maker of the, not what the draftsman of the will had intended to do, that purpose is totally defeated because the draftsman didn't have the background of this. And as I'll illustrate this with a personal experience of the people here today are aware that a will is automatically cancelled by marriage. So if you have made a will before your marriage and you marry, that will is no longer good. It stands revoked because you are married. And I did a matter, and at the cost of losing it much later in the professional life, I realized that that was one point on which I could have knocked off that claim for the property. And I still feel sad after 28 years since then, I still feel that that case I lost because of my mistake of not knowing the provisions of the Indian Succession Act. So my advice to everybody is that please do go through the provisions of the Indian Succession Act before acting as a draftsman of a will. The other thing which need to be, my experience has been that it always helps to write a few lines in the document showing the mental status of the person, that he is of sound mind. He has been operating his bank account, he has been transacting his business, he has been filing his income tax return. Then ordinarily a will is executed when you are excluding some of the natural heirs. So it's important to give reasons why you are not allowing any part of your estate, or a disproportionate distribution is being done. Then the third thing, I think we have taken a very long time. Only one other thing I would like to mention, the execution should be as much in consonance with Section 63 of the Indian Succession Act, the requirement that the testator and both the witnesses must sign at the same time, and they should see each other signing. A lot of times what happens is, while executing a will, so this you have that the draftsman has to advise, because again you see that testator doesn't know about these things. So unless you as a lawyer advise the testator in these things, the testator is likely to do it like this, that whenever he meets witness A, he'll ask witness A to sign, and whenever he meets witness B, he'll ask witness B to sign, and they would not see him signing. He would just say, I made this will, please sign it. They would not even see his signature. And if it has happened like this, that howsoever with much the attesting witness may be coached, the defect is always comes out in a good cross-examination, and the proof of a will is defeated, ultimately disproving even a genuine document. Now, this is what quickly comes to my mind. I may have missed a few points, but as I said, I think I've taken more than my share of time. Thank you.
No, it also, thank you so much. It was really nice coming to sum up the entire thing. What Malwan has said is that understanding the requirement of the testator is very important. Then comes the advisory role of the advocate to make the testator understand as to what does the law say about it, how it can be done, so as to minimize the possibility of a dispute. It has to be very clear and unambiguous, and then not to make any impressive document just to have those accolades. And lastly, and not but the least, requirements for Section 63. That's most important. That Section 63 requirements that the person has to affix the signatures and a thumb impression, and then it has to be attested by 2 attesting witnesses. So those requirements will have to be followed. Thank you so much, my Lord Justice Adlo. Along with the said this thing, may I ask one more thing? As to, though I'm conscious of the fact that it's not the court's duty to advise how this session I may be excused, can I also ask for a person holding a will, is a probate petition to be filed, or suit claiming a right under the will is required to be filed?
Is that to me, Mr. Chaudhary?
Yes, sir. Please.
There can be no thumb rule about it. It really depends upon the requirement, the purpose for which, because what happens is that getting a probate is only a proof of the will. It still may not get you what has been bequeathed to you. So you will have to take a separate action. So if you feel that the circumstances are such that the person who is holding the property is not going to give it to you merely because you produce a probate, you will still have to file a case against him. Then it's better to file a civil suit, and whatever is the defense of that person, to have that defense of that person also adjudicated besides the challenge to the will. But there may be some cases where, say, the testator has a huge portfolio of shares and company deposits. So there you would apply for a probate, so that on the basis of that document, even though all the companies are not parties, you just produce that document and you get the relief which you are wanting. So it depends from facts to facts, and there can be no hard and fast rule about it. Or if suppose some of the assets are abroad, then also it helps to have a probate, because probate is a judgment in rem. The basic difference is that a probate is a judgment in rem, while a civil suit is a judgment. Judgment in a civil suit is in personam. It binds only the parties, whereas a probate granted is proof to the whole world that there is a will. But if people are willing to accept that proof and deal with you, well and good. If they are not, you have to file a suit. That in a nutshell would be the position on this. Thank you.
I really appreciate that, sir. Coming to the next thing, may I just ask Justice Jayathnath, if none of the testing witnesses to the will are available, then in those circumstances, what are the remedies available to the profounder of the will? My Lord Justice Nath.
Yes, thank you. Good afternoon to my co-speakers, Justice Anlong and Mr. Sandeep Agarwal, Senior Advocate, and to our learned media moderators, Mr. Awal Chaudhary and Mr. Nikhil Mehta. And of course, a good afternoon to our audience who are virtually with us today and are hearing us today. Well, as far as the answer to your question lies in Section 68 of the Evidence Act. The evidence of one attesting witness is necessary to prove, provided that the witness is alive and he is subject to process of the court. Section 69 further explains that if no such attesting witness can be found, then it has to be proved that the attestation of one of the witnesses is in his handwriting and the signature of the person executing the document is also in his handwriting. It is Section 71 that comes to the aid, where one of the witnesses or any of the witnesses refuses to support the will. In those circumstances, you can lead other evidence, satisfactory evidence in this regard. And in this context, I will refer to the latest judgment of the Supreme Court of December 2019 in the case of Rajkumari versus Surinder Pal. That was also a case where a suit for partition was filed of the residential property by the sister after the death of the mother. The brother took the objection that no, there is a will of the mother in my favor and I am the absolute owner. There were two witnesses to the will. One was the advocate and one was the husband of the plaintiff. The summons was sent to the learned advocate, but he was somehow never served. He never appeared. No summons was sent to the husband of the plaintiff because obviously it was presumed that the husband will give evidence against the brother and will not support the will. In those circumstances, the Supreme Court said no, you will not be able to take advantage of Section 71 of the Evidence Act. You should have at least attempted to bring him into the witness box. If he does not support the will, it is only then that you are entitled to rely upon other evidence to prove the will. So ultimately, in those the court of course did not disallow the will only on that ground. They went into the other aspects and also concluded that no, the will is liable to be rejected. So essentially, that is the point. You have to ensure that you try and have the witnesses, if they are alive and available, summoned. If they don't come, then you have the advantage of Section 71 of the Evidence Act. That, in a short, is the answer to your question. Thank you.
I'm grateful, sir. Mr. Agarwal, would you like to add something to it?
Good evening, everybody. I think Justice Nath has already said everything. There is hardly anything else to be added to this. apart from the fact that yes, section 71 is there, and section 71 actually comes in play when there is a denial or the witnesses fail to recollect the execution of the will of the document. Then only the secondary evidence can be led. It is not a case where the witness fails to prove the will. The court will allow secondary evidence. And that is what was held in Janki, Nara and Boyer in 2003, two Supreme Court cases 91. That is just what I wanted to. Thank you.
I'm grateful, Mr. Agarwal. Thank you, my Lord Justice Lal. Mr. Agarwal, simultaneously, could you please also throw some light that what are the circumstances in which the probate can be declined by the court?
Yes. See, normally what we see is wherever there is a probate petition which is filed, you have the party filing objection to the probate. There are various reasons when the objections are filed, because there are parties who are interested in getting a part of the property of the testator. And when the testator has actually made a will, sometimes there are reasons that the court feels are doubtful to grant a probate. And those doubtful reasons basically are commonly are known as suspicious circumstances. Those are circumstances which are not really defined anywhere or in the Act, but there are a number of reasons for that, and I can just tell you a couple of those circumstances where the court has a doubt in mind and they would like to have it properly tested before a probate is granted. Some of those circumstances would be with respect to the testator's signatures, where the signatures are maybe shaky, or it is objected by the other side that the signatures are not the way or the manner in which the testator used to sign normally. Then there are conditions with respect to testator's mind. Then there are dispositions which are made in the will appearing to be unnatural or improbable or unfair in the relevant circumstances of that case, or the dispositions are made without the testator's free will and mind. And there are also a couple of other reasons where the court will be having a doubt to grant probate. This can be on the basis that the propounder was taking a prominent part in the execution of the will, or the will was made or executed under a fraud, coercion, or undue influence exerted upon the testator. Now, there are a number of cases which have been there because since it has not been defined anywhere. Recently, there was a decision which has been passed by the Honorable Supreme Court in Kavita Kanwar versus Pamela Mehta. This decision just came a couple of days back on 19th of May 2020, where it has been held that an unfair disposition of the property or an unjust exclusion of legal heirs, particularly the dependent, is regarded as a suspicious circumstance. Now, there are other reasons also, like before this, there was a decision in Umadevi Nambiar, where the court has held that while referring to the constitutional decision in the case of Shashi Kumar Banerjee, it had observed that the mere exclusion of the natural heirs or giving a lesser share to them by itself will not be considered to be a suspicious circumstance. So how these circumstances has to be dealt will depend from case to case. One has to keep in mind the testator is not there to say that it is his last will. It is upon the propounder of the will who goes to the court with the will saying that please grant me a probate. So therefore it is the onus of proving the will would be on the propounder of the will. How he is going to discharge the onus, actually, it all depends upon that. there can be reasons where you will see that a natural heir has been ousted from the will. No part of the property is of the testator under the will goes to the natural heir, but it goes to the outsider. Now that is a suspicion again, because there is a doubt which comes to the mind of the court that why this person has been ousted by the testator, unless there are specific reasons which are given under the will, or by evidence is shown that the testator was not interested in giving anything to his natural heirs. Similarly, there are also reasons with respect to because you have to keep in mind that a person who's making a will is making a will at a fag end of his life. Youngsters are not making wills. The wills are normally made by people who are of old age or they're suffering from an ailment. They know that their end is near and therefore the wills are made. So when a will is made under these circumstances, then objections are also raised with respect to the health of the testator, the mental status of the testator. Was he under some suffering from an ailment, or was he under any kind of medication? So therefore, these are all circumstances which are there and which the court has to deal upon the facts of the case as well as the evidence which is led. So therefore, the evidence plays a very vital role as far as these cases are concerned. Thank you.
Mr. Chaudhary, if I could add, you are asking Sandeep to guide people how to draft objections.
Because as the suspicious circumstances in any event, it is another very vast subject for which
Please don't take what Mr. Agarwal has said as that all these objections have to be necessarily taken.
Very true.
See, there is no ready-made in this. You have to, ultimately the test which the courts apply is the armchair doctrine. Otherwise, if you see very broadly, why is a will made? If you want everything to be equitably distributed, you have 4 children, you want them to get 1/4 each. Why would you make a will? You don't need to make a will. They'll automatically get under the personal law of succession in the case of Hindus, and similarly various other personal laws. So you make a will only when you want to discriminate. The only thing is you what Mr. Agarwal has said in addition, adding to that you have to give a reason in the will. If you don't give the reason in the will, what I said initially, that when you are excluding a natural heir, give a reason for it. Because after that, if you don't do it, you are trusting your advocate to give a reason, and the advocate may deliver or may not deliver. So, because ultimately the test which the courts apply in all these judgments which have been mentioned, all of you must have read. There is a judgment of 19th May of the Supreme Court. This is the Maheshwari, I think, which has been reported in all the major newspapers also. Now, that was a case of the testator having 3 daughters, and he had left the defense colony house to one of the daughters only, who was a spinster, if I remember the facts, what they were.
Very right, absolutely right.
Who was widowed during the lifetime of the testator and who had no son. Now, there was nothing stated in the document in that case why that daughter had been excluded. Nothing had come on record in the evidence. So, applying the armchair principle, because see, granting of a probate or proof of a will is a solemn duty of a court. So, the courts have been, what the law is, that the judge has to place himself in the armchair of the deceased, consider all the circumstances of the life and family of the deceased, and then in those circumstances, whether the will which has been made, that would have been made or not. If applying this principle that look, the person is supporting a widowed daughter throughout, but in the will he does not leave anything to her, so that becomes an unnatural thing. But if suppose the testator had not been supporting that daughter had other sources of income, By all means, he was justified in not leaving anything to her. So don't take it as tailor-made objections that in every case you have to take all this. You have to ultimately ask the client who is wanting to object to the will, why are you wanting to? Why do you say it is not a genuine document? And then you will see that slowly, slowly it will tell you why it is not. And you have to write those facts, not the standard objections.
One thing which I would like to add, I think Justice Andlaw has rightly put so. What I was trying to say was that these are normally the objections which are taken in the matters, because there is nothing which is defined that these are the specific or suspicious circumstances. It's not defined anywhere. So one has to really see from the will, okay, what are the suspicious or doubtful circumstances. So it will depend from a case to case, and how you are going to substantiate those circumstances in your favor would definitely depend from the facts as well the evidence which is going to be laid. Because otherwise it's not very easy to support those doubts. Unless until you are going to convince the court with solid evidence in your favor, you can't justify those circumstances. That is exactly what I was trying to say. Thank you.
More details will follow only when the client actually contacts Mr. Agarwal.
That's true. That's true.
Really?
Now you are not qualifying with the fees.
No, I'll come to Mr. Justice Nath now. Justice Nath, now since you were discussing this suspicious circumstances and what all is required, could I please ask you as to what is the nature of evidence which would be required so as to prove the will?
You are asking me to do exactly the opposite of what Mr. Agarwal has just said. So,
No,
I have always wondered.
I believe it means supplementing what Mr. Agarwal has said.
No, Mr. Agarwal said how not to prove it, how to ensure it is not proved. So your question is how to prove it. I have always wondered. Normally, when a testator, as Justice Andlaw pointed out, at his old age, decides to execute a will, he feels happy and satisfied that yes, I have taken care of my affairs, and hopefully the legal heirs will also be satisfied. But the kind of litigation that sometimes goes on in the form of objections to the will by the natural heirs or others, if for some reason the deceased testator could look back and see, he would be amazed as to the kind of arguments, objections that are sought to be raised by his heirs to disprove the will. So it is extremely important for the founder of the will to know that how to prove the will. First question is, what is a will? Will is obviously a document where the intention of the testator regarding the property is explained. This is defined under Section 2H of the Act. The second question is, how do you execute one will? We fall back to Section 63 of the Succession Act. The testator has to sign the will or fix his mark. The signature has to be so placed to show that he is giving effect to a will, and two or more witnesses have to sign the will, who have seen the testator sign the will and have received from the testator a personal acknowledgement of the signatures. Now, when we come to proving of the will in court, we have to fall back on two sections of the Evidence Act, Section 67 and Section 68. Under Section 67, a document is signed by a person. It has to be shown that the signature of the said person has to be proved to be his signature or is his handwriting. And under Section 45 and 47, we can fall back on the opinion of experts or of the person who is acquainted with the handwriting of the person concerned, whose signature is being sought to be proved. Section 68 of the Evidence Act provides an additional spanner in the proof, namely that at least one of the testing witnesses has to be called for the purpose of proving its execution. if such a witness is alive or subject to process of the court. The onus to prove the will is obviously on the propounder of the will. He has to lead satisfactory evidence. Now, the salient points to be kept in mind are that at the time when the testator executed the will, he was in sound disposing mind. Whatever mechanisms you have to prove that, you will have to show that. Secondly, and perhaps most important perhaps would be that he actually signed the will. The signatures on the will are of the testator. The testator understood the nature and effect of the disposition he is making. The document was signed by the testator out of his own free will. It is this kind of evidence that you would have to normally discharge. You will end up discharging the onus of the propounder. The nature and quality of the evidence has to be such, and they say, that removes all suspicions that may arise in the prevailing circumstances. It all depends on the facts and circumstances. The conscience of the court has to be satisfied that yes, the particular document is the last will and testament validly made by the testator. That is, in a small crux, the points to be taken note of. Thank you, Mr. Chaudhary.
I'm grateful, Mr. Justice Sir. So therefore, what I understand is that apart from proving that the testator had signed it voluntarily without any force, pressure, coercion, undue influence, and that the two witnesses had attested the will in the presence of the testator, he is also required to dispel any suspicious circumstances in the event that may arise during the course of trial. So that onus, I believe, would also remain upon the propounder of the will.
That's right.
I'm grateful, sir. My Lord Justice Anlaw, could I in these circumstances also ask that is it necessary that once you get a will, you only have to file for a probate and without looking at a document as to whether actually probate is required or letter of administration is required or succession could have served the purpose, or just because of the fact that since there is a will in the hands, so therefore a probate is required to be filed? My Lord Justice Anlaw.
Yeah, I've been passing a lot of orders on this. There is a rampant misconception on these concepts. Now, a probate can be applied for only by an executor. Now, in a large number of wills, there is no executor named. Or even if the executor is named, then the executor is not willing to file in the court. So, when a person who is a non-executor, that is a beneficiary under the will or any other person entitled to file, that person is filing, then you don't apply for probate. There are different provisions when you apply for letters of administration with copy of the will annexed. Now, there is a slight, though it's more or less the same proceeding, but nevertheless, the law envisages a difference. And in the last 2 years on the original side, in a fresh matter, because in a large number of matters, which one was finally deciding, one was filing that not filed by the executor, but what has been applied for is probate, and that results in a wrong final order also being passed. And there's a lot of confusion at the time of drawing up of the probate. So I started rejecting merely for this reason that all right, people, once you learn a lesson of rejection, you will next time remember it. So if you are not the named executor in the will, then you cannot apply for probate. You have to apply for letters of administration with copy of the will annexed. Then the third thing which you mentioned is succession certificate. Succession certificate can be applied for only with respect to debts and securities. So if suppose the deceased had monies in the bank which the bank is not giving, the bank is saying that produce something for me to know that all right, the money is to be released to you. There is no nomination in the bank. So that you have to apply for succession certificate. And suppose the deceased has left only debts and securities. Now, on that again, one has often come across cases where contents of bank safe deposit locker, a succession certificate has been applied for. Just 1 minute, I'll have to take this call, please. Hello.
We're pausing for a moment.
Well, can I just add one thing to what Justice Nath had said regarding proving of the important that Justice was mentioning, which has been recently by Justice Maheshwari, a 3 judges bench in Shivakumar. So the para 11, all these factors or these principles have been summarized. How the will has to be proved and under what circumstances the will becomes a doubtful and the probate is rejected or not granted. So that is a recent judgment which has taken care of all the other decisions, and thereafter Justice Maheshwari has also passed another one which just came a couple of days back in Kavita Kanwar. There also the principles which have been summarized in Shivakumar has been followed. So these are 2 recent decisions of the Supreme Court which has taken care of the entire thing. It's an elaborate judgment. So I think the youngsters who are seeing this webinar must note it down and also go through these 2 decisions of the Supreme Court.
Sir, for the benefit of the attendees, could you please just give the names of these 2 cases so that they can look at? Because I believe Shivakumar, I believe, came early this year, and then thereafter it was followed by Kavita Kanwar, I believe.
Right. It's Shivakumar versus Sharan Paspa and others. This is civil appeal number 6076 of 2009, decided on 24th of April 2020. And this case has been followed in Kavita Kanwar versus Pamela Mehta and others. The CA numbers 3688 of 2017, decided on 19th of May 2020. The first is of 3 judges bench of the Supreme Court. The second is followed is of 2 judges bench. So these are 2 matters where 2 cases where 2 decisions where all the relevant decisions passed up to date have been actually discussed. So these are 2 really important cases according to me. They discuss all the kinds of circumstances which can arise, how the court has to actually see and how a executor or the propounder of the will has to convince the court and prove the will.
I'm grateful.
Just while we are on this topic, I will just add my personal view on this is I wish the law could be a little amended so that a testator can make a will which is a little more foolproof to objections by any of the heirs. Maybe file the will in court, record the statement of the witnesses, something to reduce the litigation. I mean, it would be much better because testator cannot definitely execute a will which is foolproof. Every will is subject to litigation, can be subject to litigation depending on how the legal heirs respond. So if he has already gone into court, record his statement, the court may record that yes, the court is satisfied that it is voluntarily being made. Maybe it can help reduce litigation. I hopefully this kind of amendment would reduce the amount of litigation. This will always be my personal view.
No, I really appreciate.
I would like to add.
Sorry.
I just want to add something. You know, nowadays what we are also witnessing is that people are video recording when the will is made, when the testator is signing and the witnesses are signing the will. A video recording is made of this. That is a important factor nowadays, which was not there in earlier days. So, which is again, which will add some kind of genuineness to the will. You know that the testator and the witnesses have signed at the same time, which is an important factor, you know, in proving the will.
If I'm not mistaken, the sub-registrars are sometimes video recording the process of registration and all to bring better sanctity to the whole process.
I think Justice
If I may, I'm so sorry.
Please excuse me. That was a call I could not have missed. Otherwise, I would have left like this.
We do appreciate, sir. Please.
This was a doctor I had been chasing for 2 days. So he was calling back. If I had missed that, I would have chased him for another 2 days.
Oh my goodness.
Yeah, sorry, I had left it in between. So succession certificate is for debts and securities, and the procedure for succession certificate is very simple. There the test only is that whether the person is suitable for the grant of it and he will distribute it fairly. So that in fact I have held in at least 2 judgments that no evidence also is required and it can be decided immediately after the reply if the court finds the person suitable, and immediately succession certificate can be ordered to be given, or it can also be ordered to be given jointly to somebody else, because the only test in all these things, see, after all, what you are doing in granting a probate or a letters of administration or succession certificate is that you are making the person responsible for distributing the estate according to the will or according to the natural succession. So in succession certificate you apply even when there is no will. So you can apply for succession certificate and the court will make an order. If the will is there, then of course the court will have to go into the proof of the will. But if the parties make a statement that it may be distributed, there is no dispute. We trust the holder of the succession certificate to distribute it, then yes, it can be done. No evidence or anything is required. So this is broadly the difference which is there and which should be kept in mind while filing a proceeding, because it can play havoc and it only takes time, because if the court, if in fact it is a case for grant of letters of administration with copy of the will annexed, and the court on the basis of your prayer grants probate, it will be at some point or the other you will again have to come back to the court. Thank you.
I'm grateful, sir. In fact, to add here, recently a brother colleague approached. Hello, am I audible?
Very much.
Yeah. Yes, you are.
Recently a brother colleague approached to file an appeal against a probate petition having been dismissed by Honorable High Court for the reason that the conclusion of the trial it was discovered that there was only one witness to the vote. Now, upon examining it, what we saw was that what he was seeking was merely a succession to a share certificate in a group housing society in which the flat was not yet allotted. So the DB thereafter, instead of filing an appeal, preferred a succession petition and obtained a succession certificate for the share certificate. So the entire rigmarole of filing the probate petition and ultimately end of the day resulting in being dismissed for the reason of there being only one witness. Of course, it was not in consonance with Section 63. So these things also need to be looked up prior to filing such petitions as to what you ultimately need. Coming back to the issue, as far as may I just ask Mr. Agarwal? Hello, Mr. Agarwal, am I audible?
Yes.
What I was asking was that please. So what I was asking was that is there any consequences of the will is unregistered will?
See, a will is not supposed to be registered. There is no compulsion. It's not compulsory that the will has to be registered. But it is always better to get it registered. But registration by itself is not sufficient proof of the execution of the will if there are suspicious circumstances. So one has to clear those doubts before you are getting a probate of the will. But registration definitely adds to the genuineness of the will. That's there are two cases. If the youngsters would like to, seeing this webinar, would like to note. One is a 1982 Supreme Court 567 in Ravi Purnima Devi, and where the in the particular case, what happened was there were suspicious circumstances regarding the exclusion of the national heirs for whom no provision was made under the will. And there was no proper explanation which was given for excluding those heirs. Therefore, the court held that the registration of a will goes a long way to prove the genuineness of the will, but the evidence plays a vital role in proving the will. So therefore, even if the registration is done, the executor or the propounder of the will has to prove the will by leading proper evidence. The other case of the Supreme Court is given in judgment today, 1995 7 SC, Supreme Court 1977, in Ravindranath Mukherjee versus Padmanand Banerjee, where the will was registered and the sub-registrar actually had read over the will and explained the contents to the old lady. So the court gave a finding that even if there are certain objections which are there, that is not material because the testator understood the contents before signing the will before the registrar. Therefore, the evidence of the registrar played a vital role in granting a probate. That's all. Thank you.
So therefore, whether it is registered or unregistered is not of much consequence, but the nature of evidence which is required basically to prove the will, that is of great importance.
That's right.
I may just add here, where a will is registered, the court will obviously lean in favor of accepting such a document because it shows that somebody, the testator, took the trouble of going to the office of sub-registrar and went through the process which normally the sub-registrar follows for registering a will. So it is where one expects trouble, where testator expects that after his death there will be some trouble between the legal heirs. It is always advisable to register the will. It adds much better weightage to the testimony available to prove the will.
Certainly, I appreciate that. I appreciate that. One more important issue, which is of utmost consideration, is the jurisdiction part. I mean, as to since we have the high courts as well as the district courts which are having concurrent jurisdiction, may I ask Justice Andlaw here as to what would be the jurisdiction where a probate petition is required to be filed? Madam Justice Andlaw.
The text laid down, I think it is 270 of the Indian Succession Act, is that where the testator was ordinarily residing at the time of his demise, that is one jurisdiction in which it can be filed. The second jurisdiction is that where the estate or any part of the estate is situated. Now, section 271 is a very typical section, which you will not find equivalent in CPC or in any other statute, which also provides for territorial jurisdiction. Section 271 speaks of what later on has developed into a principle of international law, that when an international law problem comes before you, you see whether I am the most appropriate court to deal with this or some other court is better equipped or better suited to deal with this. So 271, just imagine, Succession Act is drafted nearly a century back, and in that they contain this provision that where a probate petition is filed, probate or letters of administration with copy of the will annexed is sought in a territorial jurisdiction of which the deceased was not the ordinarily resident of at the time of his death, the court can refuse, though having jurisdiction, can refuse to entertain the petition, saying that no, some other court is better suited to deal with this. Again, a very less used provision, but yet again used against me by Justice J.B. Goyal. I was trying to bring the matter to Delhi from Calcutta. So these things get etched in your mind where you have been hit hard on the very first day. I came back with rejection of the petition. So the next important thing comes, what is ordinarily resident of? Ordinarily resident of would not be that if suppose one of the sons is staying in Bombay and one is at Delhi and the parents are staying ordinarily at Delhi but are visiting Bombay and the demise takes place over there, that court would have jurisdiction because that would not be ordinarily resident of. Now the second aspect is what you mentioned about the concurrent jurisdiction of the High Court and the District Court. That actually whatsoever I may say about the law over here is determined by the advocates. If you are a High Court lawyer, you will always file it in the High Court. If you are a District Court lawyer, you will always file it in the District Court. But there also one has to assess from the clients, from the circumstances. For instance, when I was practicing, I always found that adjudication of these kind of cases in the District Court was much quicker than in the High Court, because at that time in the High Court, the evidence used to be recorded in the courts, and that date you used to get after 3 or 4 years, and then the witness may not be there, and invariably what is happening is that the witnesses are old and they are dying, so you want the case to get over at the earliest. So unless you are filing it to just keep it pending and you are not wanting an expeditious disposal, take an assessment which court is deciding these cases fast. And if you want it to be decided fast, file in that court. If the District Court is quicker, file it in the District Court. A lot of people have a misconception, again, I would say, that if you file it in the District Court, it would in any case come to the High Court and appeal. But so is it in the High Court also, it goes to the division bench. So that is a neutral factor. So considering the where the deceased was ordinarily resident of, what was the where the estate is situated, in a large number of cases what happens, the estate is largely situated in another jurisdiction, then maybe it may be worthwhile to institute it where the estate is situated rather than where he was the ordinarily resident of. Another very important factor to be kept in mind is that where the witnesses are residing, because see, this is such a case where the success or failure does not depend upon your own testimony, but on the testimony of attesting witnesses. So the propounder really has no role to play, not much role to play. So if you feel that the attesting witness is in Calcutta and it would be better that it is filed there, the estate is also there, though the deceased was ordinarily resident of Delhi, a call should be taken to file it in Calcutta so that the attesting witness's convenience is there and he can be examined. Because otherwise you are always in a quandary. You don't want to annoy him if he doesn't want to come to Delhi. And at the same time, you want his presence. If you send a summon to him or a warrant for his production, he may become angry, he may depose against you. So these are all the things which have to be kept in mind while deciding, except if the estate is spread out across several states, then of course it can't be filed in the District Court. It has to be filed in the High Court. If it is granted by the District Court, it would only be confined to that state and not to all the estate. And you may have a problem in mutation in another state. Thank you.
I'm grateful, Manoj. Now, before we put an end to this session, I must respond to the suggestion which my Lord Justice Jayantnath was giving, that we must have and or amend the laws to an extent that there's a foolproof method to so as to prove the wills, and or this proving of the wills is not required. If I may add here, under the Insolvency and Bankruptcy Code, the government has set up an information utility wherein you get the debts registered and you also get your contracts registered. So these kind of things are legally admissible in the court of law. So we can obviously, set up this kind of a registry where the testator can get their this thing registered, and so that it is not questioned and is legally found admissible in the court of law subsequent to the testator dying.
There is a provision for this, Mr. Chaudhary. In the 1955 Indian Succession Act also, there is a provision for it. I don't remember the section, it's hardly used. And I don't think in Delhi we have the facility. There is a provision for deposit of the will in the district court. But I don't really see how that would help things, because then the question would arise, who deposited? See, either we start filming that the person is coming and some kind of oath is taken, but then there would be cases that, all right, after that date the will was changed. So it's not as if it can be, maybe electronically something is possible now, that option can be explored, that you load it on your mail and it suddenly comes, you load it on your email ID, and it is sent to all your contacts on the date of death automatically.
That's the example I gave. We should video recording of the will when it has been executed. So that a lot of people
are doing that also.
Started doing that.
But then you see, video recording also, I also dealt with one case. Now they showed me in the court. Now, the camera was not a wide scope camera. So one didn't know, okay, you are seeing the face of the testatrix. You don't know whether somebody is holding a gun to her. It appeared that she is being prompted to say things. So you have to have a camera where you can see the whole room. You can make out there is, besides the professional cameraman, there is nobody else in the room. Otherwise, the objections with the ingenuity which Mr. Agarwal has and Mr. Chaudhary has, these objections can't be finished off. And since you mentioned one witness, I'll tell you a very interesting incident which came up before me also. It was in the finals category, this, I forget, probate or letters of administration. So I had started hearing, it was a contested case. I started hearing the arguments and I was just flipping through the file. And I asked the counsel for the petitioner, which is the exhibit mark of the will. He told me, and I returned, it was witnessed by only one person. So I said, this does not constitute a will. So he said, yes, I know. So I said, then why are you pursuing this? Why did you file this? So he said that I was not the one who filed it. The earlier lawyer had filed it. It came to me at the stage of evidence. I saw it immediately, but I saw in the reply to in the objections, there was no objection on this ground. So I thought that if I tell the client now that, look, you are pursuing this for 5 or 7 years uselessly, he will not stick with me, he'll go to some other lawyer. So I said, since it's been going on, the court has also not said anything. So let me continue. So then I asked the objector's counsel, I said, why did you not take this objection? Were you not aware? He said, he was also a very seasoned lawyer. He said, no, I was aware. So I said, then why did you not write it? He said, if I had written it, he said, I am in possession of the entire property. Under the will, he says that he has half share. If I had taken this objection, his petition would have got dismissed. He would have filed a suit for partition immediately. I would have lost control of the property. So it suited me to keep it pending for as long as it can. So just see how the things play out in the court.
Very right. I really appreciate it. Beautiful. So I believe we have crossed our time. It was a very interesting session. I would like to continue as much as I can. But Nikhil, do we have any questions with you? I believe we can take the question answer now.
Sir, there are certain questions by the participants. Should I ask?
Please.
Sir, first question. Sir, what is the effect of a life estate or a life interest created under a will by a Hindu male in favor of his wife? Am I audible, sir?
Yeah, Nikhil, whom do you want to answer? There are 3 people or 4 people before you. Whom do you want to answer?
Sir, any of the panelists may answer, sir.
Yes, Mr. Agarwal.
Just, I would request Justice Andlaw to answer.
See, the Section 14 of the Hindu Succession Act creates a problem in this. Section 14 provides that where the Hindu widow has a pre-existing right in some property and that property is bequeathed to her, that under the instrument she gets a limited interest or a life interest, it transforms under the law into an absolute interest. Now, that has been interpreted as that, and we have that Hindu Women's Right to Property Act and the right to maintenance under the Maintenance Act. All those things. So a large number of judgments have held that a Hindu widow is presumed to have a right of maintenance against her husband, and since she has a right of maintenance, if under the will a limited interest is given to her, it turns into absolute ownership, and she can do whatsoever she wants to do with the property, and the property would not go according to in terms of the will, because ordinarily when life interest is given, after that life of the widow, some absolute interest is given. So, but this is I would say, the most prevalent view, though the question is still at large because there are contradictory judgments of the Supreme Court. The other line of judgments goes that that was created. 14(1) is only for what happened earlier. After that, we have the Hindu Succession Act governing, under which the widow is only one of the heirs and the Hindu is entitled to divest the widow by making a testamentary disposition. So I have favored that view, and the reason which I have given is that if we see what is the concern of a person. Ordinarily, when a Hindu or a male is making he wants to give it to a son or to his sons and daughters, but he feels that it should not be that if I give it to my sons and daughters, my wife is kicked out of the property and she faces any problem. So they will write that, all right, I give a life interest to her and after her to the sons and daughters. Now, if we start reading into that it becomes an absolute estate, a Hindu would always fear that, look, my intention may not be worked out. The property may ultimately be, if suppose what happens is when both the parents are there, they have each other's support. But when one spouse is left alone, that spouse becomes more susceptible to being influenced by one of the children. I'm telling you how the mind works. When clients used to come to for purposes of preparation of the will, they used to tell all this. So that's how I'm just narrating to you what I have heard and what I have experienced. This is a big fear amongst people that whichever spouse is left alone would be more susceptible to influence by one of the children and may do some injustice to the other children. So that is why they provide for life interest. But if it is interpreted that life interest transforms into an absolute interest, the person would say, forget about it, I'll give it to whomsoever I want, leave it to the children's goodwill to give their mother. So it will ultimately result in harm to the female, she not getting that life interest also. So I have followed the other set of judgments and I have said that unless a very, very specific case is made out, there can be no presumption. In a large number of cases what I have been deciding also is because this question comes very frequently. There are no averments of dependency of right to maintenance. On the contrary, under the will, some other properties are given absolute. All the monies are given absolutely. This is seen more with respect to residential house because there is a feeling amongst people that a residential house should remain in the family. So this is what I can put in a nutshell. But yes, it's again is a very vast subject, and there are judgments and judgments. But the latest view is what I told you otherwise, that the widow is supposed to be dependent, presumption of dependence for maintenance, and the life interest transforms into a absolute interest. What I have just told you is not the best prevalent view today.
Thank you so much, Justice and Law. Justice Nath, if you want to add something to it.
Covered the whole topic. I mean, there are more than large number of judgments on interpretation of Section 14. Some have held this way, some have held that way. So I think Justice Andlaw has fully covered it. There's nothing further to really add into it.
Thank you so much, Justice. Another question by Mr. Rajesh Khanna. Can an objector who knew about the execution of the will and did not question it for 10-15 years later, when probate is sought, can such objector raise issue of limitation, which is otherwise not prescribed? Should I repeat the question or?
You have to ask one person.
Mr. Agarwal, let Mr. Agarwal answer.
Justice Nath.
Question?
Hello. Should I repeat the question?
Yes, please.
One second. Can an objector who knew about the execution of the will and did not question it for 10-15 years later, when the probate is sought, can such objector raise issue of limitation, which is otherwise not prescribed?
He will raise the issue of limitation that the probate is not within the period of limitation. Because it may have been filed much after the death of the testator. But those depend on the facts. Sometimes if the objections to the will were known and you are delayed in filing, limitation issue can arise in those circumstances. So it depends on the facts of the case. I mean, the issue of limitation would certainly arise. But the objector, whenever the probate is filed, the objector can always take an objection regarding the delay in the probate, filing a probate.
Thank you so much, Justice Nath. Another question, as we are running short of time, this would be, I think, calling off the last question. Last question for today. Can a registered will be altered by an unregistered subsequent will which specifically revokes the earlier will?
Yes. Yes, of course it can be.
Thank you so much.
One question, Nikhil, I have received. Nikhil, one question I have received. If Mr. Agarwal would be wanting to answer that.
Yes.
There's this in a will. Wife is bequeathed the entire estate, and thereafter to one of her sons. Now the wife dies intestate. Would the other sons have any right of inheritance thereafter?
Sorry, can you come again? I have not heard it properly.
By virtue of a will, the entire estate is bequeathed to the wife and thereafter to one of her sons. Now, the wife dies in the estate. Would the other sons would get any right of inheritance subsequent to her death?
If the will was to the wife and the wife died intestate.
Intestate, apart from in the will, there is also a provision that after her death, the property goes to one of her sons. Not all sons.
Only one son.
So when the wife dies intestate, yes. So correct. So when the wife dies intestate, would the other sons also get the right of inheritance?
For the conditional will, the wife till her lifetime was holding the property. Thereafter, the property was to go to the other son, to one of the sons. So therefore, if the will is to be probated, then obviously the other son would be entitled to the property after the death of the mother. The other children will not be entitled to it.
So you mean to say since that it being a conditional will, so therefore no probate can.
It was a condition in the will. So once the condition is fulfilled, the will has to be, and will is probated, then obviously the property will vest with the only the son who gets it under the will, and not to the other children.
I appreciate it. Yes, Nikhil, over to you. Thank you, sir.
Justice Andlaw, Justice, if you want to add it to it, add something to it. Sir?
I think we have already exceeded our time.
Exceeded the
We
time.
won't be disturbing you much. Back to Kamal, sir, for the vote of thanks.
Thank you so much. I am my brother, colleague Nikhil, on behalf of the members of the bar, all the attendees to this webinar, we sincerely thank you, your lordships, Justice Andlaw, Honorable Justice Jayant, for sharing your rich experiences and sparing out your valuable time today. And we are also grateful to Mr. Sandeep Agarwal, learned senior advocate, for sparing his time and encouraging us to have this webinar. And I also thank all the attendees here from the bottom of my heart. And I hope today's session was of help in enhancing your knowledge as regards the subject. I wish you all to stay safe, stay healthy. Thank you so much. Thank you, my lords, Andlaw. Thank you, my lords, Justice Nath. And thank you, my lords. Thank you, Mr. Agarwal. I'm grateful.
Thanks a lot to the
Thank you.
panel.
Thank you.
Thank you.
Thank you so much. Thank you, sir. Thank you, sir.
This meeting is no longer being recorded.